All right, hello everyone, and welcome to today's webinar, Digital Health, Emerging Legal, Regulatory, and Ethical Issues, which will be presented by me, Ryan Johnson, and my colleague, Nick Datzloff. For those of you who don't know us, I'm a shareholder and corporate healthcare attorney here at Fredrikson and Byron, and a member of our healthcare IT, and innovation, and artificial intelligence groups. My colleague, Nick, is an intellectual property attorney and a member of our IP litigation and artificial intelligence groups. So today's agenda, first we're going to cover, provide a brief overview of the digital healthcare ecosystem, and then discuss some common legal issues for digital healthcare companies. As I'm sure everyone on this webinar knows, digital health, including artificial intelligence, digital therapeutics, the Internet of Things, remote monitoring, etc., is transforming healthcare, providing consumers with greater control over their health and wellness, creating new platforms for reducing the cost and improving the quality of healthcare through the use of data, and transforming, at least in part, many healthcare companies into data companies. Emerging digital health technologies are forcing healthcare providers and other companies to view the vast amounts of data they have collected as an asset with substantial clinical, financial, and strategic value. However, the ability of these companies to realize that value depends on a number of factors, including, for example, existing legal and regulatory barriers and opportunities for digital healthcare implementation and data use at the federal and state levels. Now, unfortunately, as is often the case, the existing state and federal legal and regulatory landscapes are not keeping pace with the technology, which is rapidly evolving. Today, we're going to focus on the emerging legal and regulatory issues of digital health, with a focus on artificial intelligence and machine learning and digital therapeutics. We'll also spend time in the latter portion of the webinar discussing blockchain, the Internet of Things, and precision medicine. Now, given time limitations, today's presentation will very much be an overview and not a deep dive of these legal and regulatory issues applicable to digital healthcare companies. We'll provide an overview of regulations and rules governing data, for example, state and federal privacy and security laws, intellectual property laws, etc. We'll discuss liability issues for digital healthcare companies. We'll touch upon reimbursement, how you get paid in the digital health world, fraud and abuse, for it wouldn't be a health law webinar without at least some discussion of the anti-kickback statute and the Stark's Law self-referral prohibition. We'll also talk about some regulatory issues arising from the FDA and FTC. Again, our goal is to help you better understand at a high level many of the key legal and regulatory issues digital healthcare companies need to consider. Now, we're going to try to get through all of the material, but we might have too much to cover. But we're front-loading the presentation with AI and digital therapeutics and associated legal issues, many of which are applicable to the other technologies we'll address later in the presentation. Now, before we get to it, a couple of housekeeping items. First, if you have questions during the presentation, hover over the bottom of the screen and see the chat feature. You should be able to send Nick or me questions, which we'll try to answer, time permitting. Now, should the internet audio cut out, please use the dial-in number that was provided with instructions for today's webinar. If we don't have time to answer your questions today, we'll follow up with you after the webinar. And of course, please feel free to contact Nick or me or any member of our health law or life science groups with any questions you have about topics covered in today's webinar. Now, one more item, next month's webinar, we are hoping to cover some provider-based guidance, but the shutdown will probably delay that presentation. Next month will probably be David Glazer discussing tips for interviewing employees during internal investigations, but we're not sure. Now on with the show. The digital health ecosystem includes various digital technologies, including health and wellness apps, health IT and services, telemedicine, automation and robotics, connected devices, including the Internet of Things, consumer apps and wearables, and medical algorithms, including clinical decision support software, some of which rely upon AI and machine learning to continuously improve. Now, common to all of these technologies and the power of these technologies to transform healthcare is the ability to process and use data, vast amounts of data, to improve efficiency, reduce costs, and improve quality. Now, each of these technologies is an integrated and interrelated component of the digital healthcare ecosystem. Increasingly, these technologies are converging, meaning that many technological solutions involve combinations of two or more of the component technologies. Now, digital health promises to help reduce costs, improve access and quality to healthcare, and engage and empower consumers. But of course, the ability of digital health companies to achieve these goals depends upon the quality and the amount of data that these companies have access to, as well as existing legal and regulatory barriers. So what's driving, directing, and delaying the use of big data has been a topic of many digital healthcare panels. Many digital health entrepreneurs maintain that their companies could not exist in their current form just 5 or 10 years ago, with some noting that 90% of the world's data was generated over just the last 2 years, with almost every person carrying powerful sensors and data collection technology in their pockets, aka phones, formerly known as PDAs, and on their wrists, Fitbits, etc. Now, exponentially more data is expected to be produced as connected devices become more pervasive, producing data from virtually all aspects of our daily lives: when we wake, what we eat, how we sleep, how we communicate, when and how we exercise, and when we don't. Now, there's tremendous clinical and economic value in this data, but the key is, and the trick is, unlocking its potential by creating actionable, quality data sets and using and sharing it in compliance with applicable laws and overcoming various legal and organizational barriers, and including uncertainty and changes in the legal and regulatory landscape, challenges with obtaining reimbursement for the digital health technology, and what many companies have, lack of effective data strategy, policies, and management systems. All right, moving on to the first technology of today's webinar, artificial intelligence. So first, a question: what is AI and what is machine learning? It's a question that many often have. If you've been on the one side or the other of an investment or a potential vendor relationship, you'll see that many companies are slapping AI and machine learning on their promotional materials. Artificial intelligence is defined as the field of computer science dedicated to solving cognitive problems commonly associated with human intelligence, such as learning, problem solving, and pattern recognition. One modern definition of artificial intelligence, or AI, is the study and design of intelligent agents, where an intelligent agent is a system that perceives its environment and takes actions which maximize the chances of success. So what is machine learning? Well, machine learning is a subset of AI. It is the science of getting computers to act without being explicitly programmed. Machine learning refers to a machine's ability to keep improving its performance without humans having to explain exactly how to accomplish all of these tasks. And many of you probably read stories about machine learning teaching an algorithm how to play the game of Go or chess or various video games, all without human, serious human interaction. The algorithm itself taught itself how to play the games successfully, and better than some of the top players in the world. Now, machine learning is so pervasive that each of you probably use it dozens or more times a day without even knowing it. So think of language recognition technologies, like those found in Amazon's Alexa, Apple's Siri, and Google's Assistant, all backed by machine learning. Another example, Facebook's and Google's face recognition technology that helps people identify friends and contacts in photos. Many researchers think machine learning is the best way to progress towards human-level or general-purpose AI. Now let's spend a few minutes talking about how AI is currently being deployed in healthcare. AI, or machine learning, is being widely used in the healthcare industry, and experts predict that the use of AI will increase exponentially in coming years. Some expect that the healthcare industry will spend close to $7 billion on AI by 2021, up from the $630 million it spent in 2014. Well, here are several examples of how AI is being used in healthcare. First, virtual assistants. AI-based virtual assistants can engage with patients or consumers, providing them with valuable health information and recommendations. According to Forbes, virtual nursing assistants could help direct patients to the most effective care setting, thereby saving the healthcare industry approximately $20 billion a year. These virtual assistants, unlike humans, are available all day, every day, of course, subject to the availability of the internet, technology, etc. These virtual assistants are available to answer questions, again, 24/7, and they will provide reliable answers. Another application of AI in the healthcare setting is clinical judgment or clinical support, clinical decision-making support. Now, AI is not yet positioned to replace human clinical judgment, but it's rapidly improving, and it's had some remarkable successes. For example, Stanford University tested an AI algorithm to detect skin cancers and found that it performed at the same level as dermatologists. Another example, a Danish AI software company used a deep learning AI program to monitor human dispatchers and patients during emergency calls. Their algorithm processed the data from words spoken by the patient's tone of voice, and background noise to detect cardiac arrest, with an impressive 93% success rate compared to 73% success for humans. Another example, IBM Watson is helping oncologists make clinical decisions by providing them with valuable insights derived from the processing of huge amounts of clinical data. Another example of AI in healthcare is workflow and administrative tasks. Now, this is not the sexiest application of AI, but it's one that could save $18 billion by automating various administrative tasks. Another common application of AI in the healthcare setting is image analysis. Now, AI-based machine learning algorithms are very, very good and becoming better at analyzing images. For example, skin cancer in photos, tumors from CT scans, abnormal heart rhythms in EKGs. An MIT research team recently found that one of its machine learning algorithms could analyze 3D scans up to 1,000 times faster than what's possible by humans, thereby producing near real-time analysis of images, which of course can provide tremendous value to surgeons and radiologists. Now, there are many, many more examples we could cover, but our time is limited. In some, machine learning's ability to process huge data sets far beyond what humans could do on their own and provide valuable, actionable clinical insights to lead to better outcomes, lower cost of care, and increased patient satisfaction. All right, so what are the legal and ethical issues associated with AI? Well, there are many, but today we're going to cover those arising from federal and state privacy laws. We'll talk a bit about liability arising from the use of AI in the clinical setting. We'll talk about how the FDA regulates the use of AI in healthcare. We'll talk a bit about fraud and abuse, and then my colleague Nick will talk about some of the IP issues arising from AI. So the power of AI or machine learning depends on the availability of substantial amounts of quality data. Now, algorithms learn or are trained by processing, again, large amounts of high-quality data. The good news, many healthcare providers, insurers, device and pharma companies, and others have access to and control very large amounts of data. The bad news, state and federal privacy laws create many barriers to using and sharing that data to realize the full potential of those data sets. For example, the Health Insurance Portability and Accountability Act of 1996, commonly known as HIPAA, is a federal law which governs the use and disclosure of protected health information, or otherwise known as protected health information, it's PHI, by covered entities defined as health plans, healthcare clearinghouse, and healthcare providers who electronically transmit PHI, and also the business associates of those covered entities. Now, HIPAA breaches can result in substantial penalties, with the amount of penalties based upon a variety of factors, including factors such as whether the disclosure breach was unintentional or was the result of willful neglect. Now, the general HIPAA privacy rule is that PHI cannot be disclosed without the patient's authorization, unless a HIPAA exception applies. So, how do AI, machine learning, or other digital healthcare companies get access to vast amounts of data owned or controlled by covered entities and their business associates? how can covered entities and business associates lawfully share this data with digital health companies so they can improve their technologies, their algorithms, and fully realize the clinical and economic value in the data? Well, there are a couple of options, including the following. One, HIPAA's exception for treatment, payment, and healthcare operations. HIPAA permits a covered entity to use and disclose protected health information with certain limits and protections for treatment, payment, and healthcare operation activities. Thankfully, digital health data sharing arrangements between or among covered entities, their business associates, and third parties can often be structured to fit within HIPAA's TPO exception, meaning that the information can be shared under the arrangement without a HIPAA-compliant authorization from patients. However, all this is good news. Any such disclosures would still need to fit within HIPAA's minimum necessary disclosure requirements and comply with any more stringent state laws, rules, or regulations governing the use or disclosure of the health information. Another option for sharing of the information is for covered entities and business associates to de-identify the information. The HIPAA privacy rule states that once protected health information has been de-identified, covered entities can use or disclose it without really any limitation. The information is no longer considered PHI. So how does a covered entity or a business associate go about de-identifying PHI? Well, there are two options. One involves a formal determination by a qualified expert that the information has been de-identified, and the other option involves removing certain specified identifiers, including, among others, name, telephone number, email address, social security number, and medical record numbers. So there are options for covered entities and business associates to lawfully share information with digital healthcare companies, including AI machine learning companies. Again, one is the TPO exception, the other is de-identification. Of course, they can also share or gain access to information if there's a HIPAA-compliant authorization from the patients, if the information is not PHI, and possibly under various other HIPAA exceptions, again, in each case, subject to any more stringent state or federal laws. So feeding the machine. How do you feed the algorithms? What are the questions you need to ask? So regarding HIPAA, again, not every digital healthcare company will be a HIPAA-covered entity or HIPAA business associate. For those covered by HIPAA, compliance is a must, or better put, non-compliance can be very expensive and potentially fatal to a company. For those not covered by HIPAA, it remains critically important for digital health companies to understand the other state and federal legal obligations for acquiring, sharing, and using data, as well as their contractual obligations relating thereto. Again, remember, many states have their own privacy, security, and data breach laws. Now, some practical advice for digital health companies that need access to or need to use data. There are some questions they should ask, including the following. Does the data that they're obtaining include personally identifiable health information? If so, the company will need to make sure that it can be shared and used under applicable federal and state law, including HIPAA, which we just discussed. The company should also ensure that the intended use or disclosure does not violate any applicable privacy policies found on a company website or in its terms of service. Two, with respect to publicly available data, companies are generally free to use information found on government sites or in government reports, like those from CMS or HHS. However, certain information found on the web and generally available to the public, like social media posts, may not be as freely available to use. Much depends on the terms of service and policy of the relevant website and social media company, and there may be laws that limit the ability to access and use that data. Three, if a company has obtained access to data through a license or similar agreement, it's important to ensure that the use and sharing of that data is in accordance with or compliant with the terms of that agreement. Now, when entering into or negotiating a license or similar agreement, it's important for all parties to understand and document the agreed upon uses of the data, including health information. Finally, due diligence. Companies should also confirm that any data they receive and plan to use was collected and shared in accordance with applicable privacy laws and not in violation of any agreements, for example, a license agreement, or policies, for example, policies on a company's website. Moving on to tort. In healthcare, physicians and other healthcare providers sometimes make mistakes, sometimes commit malpractice, and sometimes are sued. The question is, under tort law, who should be liable if physicians and other healthcare providers make decisions based upon recommendations of clinical decision support software, including that backed by machine learning or AI. Now, in terms of negligence, most personal injury cases in malpractice are determined based upon whether a defendant was negligent. To prove negligence, a plaintiff must establish that the defendant owed a duty of care to the plaintiff, that this duty was breached, that the breach was the actual and proximate or foreseeable cause of the plaintiff's injuries, and that the plaintiff suffered actual damages from the breach. Now, if a person is injured by an AI-controlled program or device, many plaintiffs will struggle to establish at least one essential element of negligence, at least with respect to the algorithm itself, and that could be foreseeability. Because the decision-making of advanced artificial agents, machine learning, may not be predictable, especially when the AI systems continually evolve based upon novel input data not predicted or necessarily controlled by its designers. Without this predictability or foreseeability, there's a question about how the current legal system will hold AI developers liable if the injuries were not foreseeable. Now, historically, courts have been reluctant to hold software developers liable, unless they were somehow directly negligent or could foresee the risks of the use of their program. So who should be responsible? As things currently stand, with respect to malpractice claims brought by patients, healthcare providers will be those first in line for liability. Licensed professionals have a duty to evaluate and confirm the quality, accuracy, and reliability of any recommendations made by clinical decision support software, meaning that they'll generally not be able to avoid malpractice liability for making decisions based upon an algorithm's recommendations, or at least not yet. That's not where the standard of care is at this point. Now, there's a challenge. How do healthcare providers and professionals do this confirmation of quality, accuracy, reliability? Because oftentimes the algorithms themselves have a black box feature, meaning why they're making certain recommendations, providing certain clinical insight, it's not obvious. And that's the magic oftentimes of machine learning. You put in a lot of data, and the algorithm teaches itself to identify patterns and makes recommendations. And the professional, the provider, might not understand how or why the algorithm arrived at its conclusions. However, that is the obligation of the provider, given this current standard of care. Now, in the future, there may be a risk of second-guessing or rejecting an algorithm's recommended diagnosis or treatment. That's not where the standard of care is today, but as AI improves, machine learning improves, again, providers might be liable for second-guessing or deviating from the recommendations from these software programs. But that's not where we are today. So before moving on to the FDA, some recommendations, practical advice. When negotiating agreements for the licensing of clinical decision support software, including AI or machine learning, it's important to allocate liability in the agreements between the providers and the software vendor. It's important to develop policies governing the use of clinical decision support software and train people on its use. All right, moving on to the FDA. So what are the regulatory challenges for digital healthcare companies? Well, as background, the U.S. Food and Drug Administration has jurisdiction to regulate medical devices, broadly defined to include any instrument, apparatus, implement, machine, contrivance, etc., intended for the use of the diagnosis of disease or other conditions, or in the cure, mitigation, treatment, or prevention of disease. The definition is broad enough to encompass certain software applications, which, absent clarifying laws or regulations, such as those in the 21st Century Cures Act, which we'll discuss in this webinar, could stifle innovation in digital health by placing digital healthcare companies within the FDA's regulatory framework, or creating ambiguity as to whether their products would be FDA-regulated devices. As more background, the FDA uses a risk-based regulatory framework for medical devices, in which the risk posed by a device dictates the level of regulatory scrutiny to which the device is subject. Now, the FDA has established 3 device classes. Class 1 devices present the lowest risk of harm to patients or users. Accordingly, most Class 1 devices have been exempted by regulation from marketing authorization, FDA clearance, or approval requirements. Notably, however, such devices must still comply with certain general post-market FDA requirements. Class 2 devices represent an intermediate level of risk. Class 2 devices include a wide range of products, certain of which have also been exempted from the marketing authorization requirements. Those that have not been exempted, however, must receive FDA clearance prior to marketing under Section 510K of the Federal Food, Drug, and Cosmetic Act. Now, such clearance is granted when submitted information establishes that a proposed device is substantially equivalent to a predicate device, which is usually another legally marketed Class 1 or Class 2 device that has the same intended use and similar indications for use and technological characteristics. Finally, Class 3 devices include high-risk products such as life-sustaining, life-supporting, or implantable devices or novel devices that do not have predicate on which to base substantial equivalence and doesn't warrant down classification to Class 1 or 2. Now, in the digital health space, it's worth noting that the FDA has adopted a policy of enforcement discretion, i.e., does not enforce the applicable regulatory requirements to certain products that, while they constitute medical devices per the definition described above, such digital health platforms present little risk and therefore not subject to the active regulation by the FDA. The FDA's goal was to encourage innovation, at least with respect to those products that create little risk to patients. Now, over several years, again, the FDA has outlined its general approach to regulating digital health technologies in a series of agency guidance documents. For example, at the end of 2016, Congress amended the FDA's statutory authority over digital health in the 21st Century Cures Act, which, following the amendments, now excludes certain low-risk software functions from the statutory definition of device. The Cures Act was largely consistent with the FDA's approach to regulating digital health, namely exercising enforcement discretion. Given the FDA's enforcement approach, one might ask why statutory change was necessary. Well, stakeholders and investors desired more certainty, since current or future FDA officials have the authority to change an enforcement discretion policy at any time. So, responding to these pressures, Congress, via statute, decided which software function should be excluded from the FDA's device definition, and which function should remain within that definition. However, as is almost always true, statutory language is imperfect, includes ambiguity, and room for interpretation. Thus, the FDA decided to clarify certain matters through guidance documents, several of which were recently released. In December 2017, the FDA announced new significant policy documents to advance the FDA's approach to the development and proper oversight of innovative digital health tools, acknowledging that consumers and healthcare providers are increasingly embracing digital health technologies to inform everyday decisions. From fitness trackers to mobile applications tracking insulin administration, these digital tools can provide consumers with a wealth of valuable health information. In releasing the policy documents, the FDA noted that clinical evidence demonstrates that consumers who are better informed about health make better and more efficient decisions, take steps to improve their lifestyles and their health choices, and often experience better outcomes. I will now turn to the 2017 FDA guidance documents, the first being Clinical and Patient Decision Support Software, otherwise known as the CDS draft guidance, and the second, the Section 3060 guidance. The FDA issued the Clinical and Patient Decision Support Software draft guidance in December 2017. It was intended to make clear what types of clinical decision support software would no longer be defined as a medical device, including helping providers and ultimately patients identify the most appropriate treatment plan for the disease or condition. One example cited by the FDA is software that can include programs that compare patient-specific signs, symptoms, or results with available clinical guidelines to recommend diagnostic tests, investigations, or therapy. The FDA observed this type of technology has the potential to enable providers and patients to fully leverage digital tools to improve decision-making. The FDA expressed its goal of encouraging developers to create, adapt, and expand the functionalities of their software to aid providers in diagnosing and treating old and new medical maladies. And most importantly, the draft CDS guidance attempts to make clear what types of clinical decision support software would no longer be defined as a medical device, and thus would not be regulated by the agency. For example, generally clinical decision support software that allows the provider to independently review the basis for their recommendations are excluded from the FDA's regulation. The FDA has emphasized the importance of independent review by a qualified provider. And again, this is consistent with the standard of care we talked about in the context of malpractice claims several minutes ago. This type of clinical decision support software suggests that a provider order liver function tests before starting statin medication, consistent with clinical guidelines and approved drugs. Now, per the new guidance, the FDA will continue to enforce oversight of software programs that are intended to process or analyze medical images, signals from in vitro diagnostic devices, or patterns acquired from a processor like an electrocardiogram that uses analytical functionalities to make treatment recommendations, as these remain medical devices under the Cures Act. The guidance does not exclude clinical decision support software from the definition of device if the software acquires, processes, or analyzes, 1, a medical image, again, 2, a signal from an IVD or signal acquisition system. The guidance also addresses, one moment please. All right, some final observations in the guidance. The software exclusion from the definition of device may be fairly narrow. Many emerging cutting-edge CDA software can remain subject to FDA regulation. For example, the clinical decision support software that incorporate machine learning or AI. Why is this? Well, one requirement for excluding the clinical decision support software from the FDA's definition of device is that the software must enable a clinical provider to independently review the basis for the clinical decision support software recommendation. According to the guidance, the healthcare professional should not rely primarily on the recommendation made by the CDS software. With advanced programs or software, the functionality or performance may be much better than the independent provider of medical decision-making, such that the professional would be foolish not to rely on the recommendations. Now, given the black box nature of some AI machine learning-based programs, it might be impossible for some physicians to independently review the basis of a recommendation. I'm sure we'll be receiving additional guidance from the FDA and Congress over coming years. And moving on to the Section 3060 guidance. This guidance outlines the types of software that the FDA no longer considers to be a medical device. For example, lifestyle or wellness apps. So again, not devices, software with healthy lifestyle claims, such as weight management, physical fitness, relaxation or stress management, mental acuity, self-esteem, sleep management, sexual function, when not related to the diagnosis, cure, mitigation, prevention, or treatment of a disease or condition. So moving on to the guidance related to software as a medical device, clinical evaluation. Now, software as a medical device is one of 3 software types recognized by the FDA as it relates to medical devices. Now, software as a medical device is defined as software intended to be used for one or more medical purposes that perform these purposes without being part of a hardware medical device. Software as a medical device includes phone-based software that allows the viewing of images obtained from an MRI or other imaging device for diagnostic purposes. It also includes diagnostic software that uses the triaxial accelerometer, a consumer digital camera. Notably, software that simply uses data for a medical device but does not have an independent medical purpose, or software that monitors the functioning of a device, do not meet this definition. The focus of the final guidance is the 3-part clinical evaluation process, consisting of valid clinical association, analytical validation, and clinical validation. Now, again, the most important part for today's presentation is the independent clinical validation. Again, the ability of a clinician to independently validate the accuracy and quality and the basis for a recommendation. Give me the slide. So moving on to the FDA and AI. Now, certain AI-based health products will be excluded from the definition of device if, among other things, the software allows, again, the independent review of clinical recommendations by a healthcare professional. As I mentioned earlier, that can be challenging given the black box nature of some AI machine learning-based algorithms. Again, importantly, the FDA does support innovation in areas with evolving regulatory standards and also supports the use of AI. Moving on to fraud and abuse briefly. As many of you on this webinar know, the anti-kickback statute is a federal law which makes it illegal to offer, solicit, make, or receive any remuneration intended to influence referrals under a federal health care program, Medicare, Medicaid, TRICARE. There's another federal law, the Stark Law, the federal self-referral prohibition, which prohibits a physician from making referrals to an entity for the furnishing of certain designated health services if the physician or immediate family member has a financial relationship with that entity. Many states have their own versions of these anti-kickback or self-referral prohibitions. Many states also have fee-splitting prohibitions. We're not going to go deep into each of these right now, but the most important takeaway should be that any business arrangement involving healthcare providers and others covered by these laws should ensure that the arrangements are carefully structured to comply with these laws. For example, ensuring that any compensation arrangements are consistent with fair market value and the compensation is not based upon the volume or value of referrals. And with all of that, I'm going to move on and hand the mic to my colleague Nick, who will talk about some of the AI components with IP considerations.
Thanks, Ryan. So when we're thinking about how intellectual property plays a part in artificial intelligence, I think there are really three components of AI that we should be thinking about. One, the hardware involved with any technology or product. For example, a wristband tracker or a heartbeat monitor, sort of the quintessential physical devices that we normally think when we think of IP. Two, the software or the algorithms that are working behind the scenes to make the product work or drive the results for the computer software. And three, the data that is part of the product or that is utilized by the software algorithms. Skip to the next slide. Now, when we think about each of these three components, each one raises a number of important questions relating to IP. One, can you protect the hardware, software, or data so that others aren't able to copy it or use it for their benefit without your permission? Two, who is the proper party to identify as the inventor or the author of the intellectual property, which can impact who has the original rights to the IP? Three, do you have ownership of all the necessary components for the product or the device? Was this a joint development product? If you're relying on the data, do you have the rights to use the data, as Brian already talked about? And if you're going to be relying on continued inflow of data, have you ensured that you will continue to have access to all of the necessary data to make the product work? Finally, as Ryan mentioned, you want to consider what impact the black box of AI may have on the marketability of your product. If the product is tasked with providing healthcare decisions, will doctors or users need to know the process, or at least better understand the process behind the scenes through which decisions are made in order to have the confidence or trust in the software or the product? We can go to the next slide. The three main areas of intellectual property that apply to AI considerations are patents, trade secrets, and copyrights. Each one plays a different role in the protection of AI, and although we don't have time today to get too far into the details of each, I wanted to at least provide you with a brief overview of how they differ and what important consideration you want to keep in mind. Patents, or at least utility patents, and there are some other patents, but for our purposes, utility patents offer some of the strongest protection. They protect the underlying working and idea of the product or the software and grant the patent holder a right to exclude anyone from making or selling the invention for a limited term, 20 years in the US. In exchange for this very powerful protection, however, you must disclose the details of your invention in the patent application. And there's also some downside to it because it requires some time before the patent will issue and you can enforce your rights. Generally speaking, you'll also need to pursue patent protection separately for different countries. So if you're looking for protection outside of the US, you'll have to consider other means of protecting it abroad. Trade secrets are another form of IP protection. They protect a very broad spectrum of information, which can include ideas and functionality. And they offer immediate protection in that you don't need to apply to any office to have the issuance of a trade secret as long as you meet the requirements. In contrast to patents, however, trade secrets require secrecy rather than disclosure. And the failure to keep a trade secret a secret, for example, through public disclosure, will result in you losing all of your protection. Trade secret law also does not protect against the independent discovery or the independent invention of whatever you're trying to protect. Finally, copyrights protect original artistic works, but are limited to the specific expression of the work and do not protect the functionality or utility. And although you can register your work, again, protection exists immediately once the work has been fixed in a tangible medium. We can go to the next slide. When we talk about patent protection, we're just obviously going to hit a few of the highlights of it. And the three essential elements, though I should note there are others, are with regard to the eligibility of any invention and the novelty and non-obviousness. The two requirements regarding novelty and non-obviousness both relate to the fact that you had to have actually invented something. Sounds not shocking. If your invention was previously publicly known or described in a public document, then you won't be able to get a patent for it. Likewise, if the invention you've described would have been obvious to someone of ordinary skill in the art or in the industry, for example, if by looking at two public documents they collectively teach the invention, you again likely won't be able to get a patent. The big one here for AI in particular, however, is with regard to the eligible subject matter, which is Section 101 of the Patent Act, which limits the eligibility of certain types of inventions. And although the statutory language is quite broad, there have been judicially created exceptions by the courts, for example, of abstract ideas that cannot be patented. And although the Supreme Court has never defined what constitutes an abstract idea, through a string of recent cases, the ability to patent inventions relating to software, business methods, and the manipulation of data, all of which strongly relate to AI inventions, has been significantly hampered. The United States Patent and Trademark Office has recently issued additional guidance on the application of this case law, but it's safe to say that there has been a considerable amount of confusion on exactly how the law is applied to each particular invention. Now, the European Patent Office recently issued specific guidelines on the patentability of artificial intelligence in Europe, so it's possible, as this becomes more of an issue, that the U.S. Patent and Trademark Office will do the same. For now, it has not issued any such specific guidance. As I mentioned before, to receive a patent, you have to apply through an application and then go through a prosecution process, working with an examiner from the Patent Office to ensure that your invention is patentable. If you're successful, then your patent will issue. And recent statistics suggest that it takes about 23 months or so for a patent to issue. Okay, we can go ahead and then now move to the trade secret slide. The next possible area of protection are trade secrets. As I mentioned before, these protect a very broad area of information and have few general requirements. The key requirements are that the information must have independent economic value from not being generally known or ascertainable, which is usually a pretty easy standard to meet. The harder and the more burdensome part is that in order to have a trade secret, you must have taken reasonable efforts to maintain its secrecy. And the reasonableness depends on the specific context of the situation. But in addition to contractual limitations for anyone dealing with the trade secret, it often also includes restricting access to only necessary individuals and may require providing some security measures as well, which can get expensive. Until recently, the area of trade secret law was largely governed by state law. However, with the enactment of the Defend Trade Secrets Act, there has been provided a federal cause of action for trade secret misappropriation, which many have seen as providing more powerful remedies and as strengthening the protection available under trade secrets law. The big downside of trade secrets, however, as we already noted, is that protection can evaporate in an instance. If your trade secret is publicly disclosed, so the requirement of secrecy is broken, you will lose your trade secret. It also does not protect against independent discovery. So if you have the greatest recipe for making chocolate chip cookies, for example, if someone independently comes up with the very same recipe, you've lost your protection, and there's no way for you to preclude them from making the same cookies. We can go on to copyrights. The other form of protection that relates to AI innovations is copyright, which applies to original works of authorship and includes computer programs, graphics, appearance, word choice, and compilations of data, to name a few. Importantly, however, it does not protect the underlying idea, procedure, or process. So if you have an article that describes a particularly innovative way of providing healthcare to diabetes patients, for example, you would be protected against any wrongful copying or distribution of the article itself, but there would not be any protection, at least through copyright, from someone practicing the details of what you described in the article. Again, the nice thing about copyrights is the protection exists immediately as soon as the work has been fixed in a tangible medium of expression. You don't need to register your work with the Copyright Office, although registration does provide several benefits, such as allowing you to file an infringement suit and having prima facie evidence of the validity of the copyright. And I should note, if you're relying on copyright law, you also want to consider including some encryption or anti-circumvention technologies, since there are laws that protect against parties bypassing technology protection measures. Let's go to the next slide. So now that you've had this mini crash course on IP law, you may be wondering which is the best means of protection for my particular work in artificial intelligence. And the answer is it really depends on the circumstances of your invention and your goals. But a few general points that are good to consider whether patent protection or trade secret protection might be more suitable are ones that I've highlighted in this slide. For example, can the invention be reverse engineered? If it's something that someone can lawfully reverse engineer or is likely to be independently discovered, patent protection might be a better bet. If you're likely to have investors who want to see tangible IP rights, patent protection might be a better choice as well. But you also want to consider if you can even get patent protection. As I mentioned, there are some difficulties with doing that in light of more recent case law. And if you can't get patent protection, then trade secret protection might be your only option. You'd also want to consider the cost. Obtaining a patent will take some time and money, and you may be forced to defend its validity should you try to assert it against another party. The best course of conduct when you think you have an invention that may be of value is to discuss your options with an IP attorney early in the process. Particularly with the speed at which artificial intelligence is moving forward, it's essential to start that process very early. We can go to the next slide. I probably will not spend much time on this, but I did want to very briefly touch on the fact that as AI has become more sophisticated, it has actually moved from being intellectual property itself to generating intellectual property. And for those individuals that are dealing with artificial intelligence that is generating content, it presents several complex and novel legal questions. For example, if your AI software itself develops an invention or creates music, as some have, for example, do you have to list that AI is an inventor or an artist? Now, these questions are very much on the cutting edge of the law, and most of the guidance so far has indicated that the inventors and authors are limited to humans. You can, in particular, take a look at quotes that I have there from the guidance that the Copyright Office has issued. But you want to keep an eye on these issues if you're working with artificial intelligence that is generating content, because if you fail to list certain individuals, it can have severe consequences. We can go to the next slide. Finally, you want to consider the ownership and accessibility for any inventions, in particular with regard to data. This is almost always going to be governed by contracts and licenses, and Ryan already touched on a number of the considerations that you want to think about when you're going through the process of negotiating or accepting agreements. And rather than trying to list example provisions you may include, excuse me, which is again pretty context specific, I wanted to identify at least a number of considerations you'll want to keep in mind as you're working through such contracts. For example, are there parties involved with your invention or data that are going to be separate from your particular organization? Have you clearly and expressly identified your rights with respect to the other parties? If you're acquiring data from other parties, are there any restrictions on the use for the data that may impact your work? And have you provided any indemnification, or do you carry any liability with respect to maintaining the data? And in light of the numerous data protection laws that have continued to expand, you also want to be sure to consider any privacy considerations for the data that you're storing or working with. Next slide, please. What are the key takeaways when it comes to IP and AI innovations? Well, one, you want to think about what is driving the value of your AI. Is it the hardware? Is it the software? Or is it the data? And then you want to protect what is most valuable, or at least that's where you want to start. Two, consider what is the best means of protection. Again, there are different routes and different considerations you want to take, but the best thing to remember is to start early. 3, be sure to have all the rights to the data that may be necessary for your AI to work now and in the future. And finally, consider what your competitors are doing with respect to AI. We haven't talked much about this and the litigation side of intellectual property, but if your competitors are obtaining a patent on a technology that relates to your work, they may be able to enjoin you from violating their patent rights and shutting down your business if they can show that you're infringing on their patent. And with that, hopefully you've had at least some useful information to consider on the IP side as you're working with intellectual property and artificial intelligence. Ryan, I'll turn it back over to you.
All right, thanks, Nick. Let's move on to digital therapeutics. So what are digital therapeutics? Well, these are interventions based on software. I'm going to quickly summarize 3 companies in this space to give you a better sense of what companies are doing in the digital therapeutic space. First is Pear Therapeutics, which is a software-only substance abuse therapy. So it's a digital therapeutics company that was the first to receive FDA approval for a prescription-based digital therapeutic with claims of improving clinical outcomes in a disease. So Pear's first approved product was approved in September 2017. It was known as Reset, which is a digital treatment for patients with substance abuse disorders. It's a 12-week duration program that gets FDA cleared. The second is Proteus Digital Health. It received FDA approval for Amplify MySight, a digital therapeutic that uses a sensor-equipped pill with a companion app to be used for treatment of adult patients with schizophrenia, bipolar disorder, and other major depressive disorders. The Amplify MySight system is intended to track if Amplify MySight has been taken by patients. Now, this system has 3 components. First, Amplify MySight is comprised of a tablet embedded within an IEM sensor. It's an antipsychotic. This sensor is the size of a grain of sand and is made up of ingredients found in food. The IEM sensor activates when in contact with stomach fluid and communicates to a wearable sensor called the MySight patch. The IEM sensor is then digested and eliminated from the body. 2, the MySight patch detects and records the date and time of the ingestion of the tablet, as well as certain physiological data, such as activity level, and communicates this and the tablet ingestion data to the MySight app on a compatible mobile device. This app also allows individuals to review their objective medication ingestion and daily activity level, as well as enter their mood and rest. They can also invite others to review their data. Well, the third example is Akili Interactive Labs. Now, this uses a video game-like approach to treat children with ADHD. Now, according to the company, its game improves the attention of children with ADHD, a conclusion it reached based upon a trial involving 348 children ages 8 to 12. After 4 weeks, patients who used the platform, Akili's platform, did better on an attention performance index against its primary endpoint. Moving on. What are some of the legal and regulatory challenges for digital therapeutics companies? Well, some are the same as we covered with respect to AI, privacy and security issues. FDA, right? The intellectual property issues that Nick discussed are also applicable to digital therapeutics companies, of course. We're going to talk now, though, about a couple of other legal issues that digital therapeutics companies need to consider, and these are also applicable to other digital health companies. We're talking about the FTC rules that provide that direct-to-consumer communications and advertising must be truthful and non-deceptive. Advertisers must have evidence to back up their claims, and advertisements cannot be unfair. We're also going to talk about briefly about the Consumer Product Safety Commission, and then finally about the Americans with Disabilities Act. So the FTC has jurisdiction to make sure that advertising is truthful and non-deceptive, that advertisers back up their claims with evidence, and again, that advertisements are not unfair. These rules apply to many digital health companies, including digital healthcare companies, digital therapeutic companies, mHealth, consumer-facing apps, precision medicine, etc. A couple of cases to illustrate how these advertising rules could come into play. Now, the first is actually an FDA case. It's not an FTC case, but I think that the facts will help you understand how the FTC would look at advertising issues. This is the Cheerios case. So General Mills once claimed that whole grain oat cereal would lower cholesterol and reduce the risk of heart disease and cancer. Now, the FDA allows some health benefits of foods to be advertised, but within strict limits. For instance, a company can say that a diet low in saturated fat and high in fiber-rich foods, such as fruits, vegetables, whole grains, may reduce the risk of heart disease. The FDA claimed, in this case, that General Mills' statement that the product is clinically proven to help lower cholesterol made the product a drug under federal law, and therefore subject to the FDA's jurisdiction. According to the FDA, the statements were misleading, and that Cheerios' claim did not convey that all these factors together could help reduce the risk of heart disease, and did not enable the public to understand the significance of the claim in the context of a total overall daily diet. Again, this was an FDA case, but the FTC could arguably have brought a similar claim based upon misleading advertising. A second case that's somewhat amusing is a case involving mobile apps, known as the Acne app or Acne owner. In these cases, the FTC brought an action targeting health claims that in the mobile application marketplace. The FTC alleged that the mobile apps were advertised to work in the same way. Both of these apps claim to treat acne with colored lights emitted from smartphones or mobile devices. Consumers were advised to hold a display screen next to the area of skin to be treated for a few minutes daily while the app was activated. According to the FTC complaint, there were approximately 3,300 downloads of the apps offered for 99 cents in the marketplace. The marketer of the app claimed the app was developed by a dermatologist. A study published in the British Journal of Dermatology showed blue and red light treatments eliminated acne bacteria and reduced skin blemishes by up to 76%. Again, there were approximately 10,000 of these apps downloaded. The FTC charted that the acne treatments claims for the apps were unsubstantiated. It also charted the marketers of the app falsely claimed that the study proved that blue and red light therapy is an effective acne treatment. The settlement barred the marketers from making acne treatment claims about their mobile apps and other medical devices, as well as the safety, performance, benefits, and efficacy claims about any device without competent and reliable scientific evidence. Another federal agency that has the ability to regulate digital health products is the Consumer Product Safety Commission. It's not responsible for consumer product for privacy, but is responsible for product safety. Moving on, since time is limited to the ADA, I want to mention before we sign off that the healthcare sector has become a target for website accessibility lawsuits by many plaintiffs' law firms. Now, the Americans with Disabilities Act, Rehabilitation Act, Section 504, and ACA Section 1557 all contain anti-discrimination provisions covering disabled persons. And plaintiffs have alleged, and most courts have agreed, that this covers technology such as websites and apps. And this will also include healthcare websites and apps. One recent example is that Epic was sued just last month by the National Federation of the Blind because the Epic tool was not accessible to employees and workers. Now, if you want more information about the ADA and how it applies to digital health, contact my colleague Steve Helen. He's done a lot of work in this space, published an article on this topic. Happy to make introduction or put you in contact with Steve. This is his area of expertise. Some practical actions to reduce risks is that companies should adopt accessibility policies, require vendors to provide accessible work products and services that are accessible as defined by the ADA, obtain cyber liability insurance with coverage for ADA and rehabilitation claims, and most importantly, do not ignore or throw out demand letters from plaintiffs' firms alleging unlawful discrimination under the ADA. So what areas of medicine are best positioned for digital therapeutics? This is obviously going to move and the list could change from time to time, but currently, I think those therapies that target chronic diseases or behavioral health, there's a shortage of providers compared to the needed patient contact. Family members can be engaged through lots of these technologies to help supplement care. Those areas that have a lot of data and multifactorial diagnoses are well positioned to take advantage of the power of digital therapeutics. And also certain closed-loop devices can be used well in the digital therapeutics space. Now, evolving business models in the space include direct-to-consumer and patient. allowing individuals to access these technologies, these treatments, via app, via website. There's a question whether employers or payers will cover, digital therapeutic services. Again, that's an evolving matter. Many more employers and payers are adding digital therapeutics to their offers or considering it because of the power to improve quality of healthcare, manage care, lower costs. As we continue to move towards value-based healthcare, digital therapeutics will definitely have a role to play in that ecosystem. Reimbursement for digital therapeutics, it's often a model better suited in the value-based healthcare context for gain sharing rather than traditional fee-for-service. But again, this is a rapidly evolving area. Reimbursement is obviously a huge issue for digital healthcare companies. We want to make sure they get paid for the service or product they're offering, of course. So we're at the bewitching hour. We didn't cover blockchain, IoT, or precision medicine. We'll get to you, of course, you have the slides. We can follow up with additional information on those technologies and some of the legal issues. But almost everything we talked about today applies to all of those technologies. If you have any questions, please feel free to email or contact Nick or me. We're happy to answer those questions. If the question is really one of general applicability, we'll try to include a follow-up answer for all the attendees. And of course, if you have any questions about the technology, the legal issues we covered today, feel free to reach out not only to Nick or me, but any member of our health law, life sciences, intellectual property, artificial intelligence, or many other practice groups here at Fredrikson and Byron. Thank you for listening today. So we couldn't get through all of the material. Hope you learned something and enjoyed the presentation, and look forward to seeing you in future webinars. Thanks a lot.